Hi guys, this is Tina speaking. Today we're going to talk about something that a lot of people were hesitant or even try to talk or what to talk about. It is a topic that was considered as a taboo. And yes, today we're going to talk about the last will and testament. Before you have a thought of choy in Chinese or touch wood in your mind, I hope you will give it a try in listening to this short video. A will is extremely important to everyone. It applies to you, to me, your neighbor, or almost everyone. You are welcome to join us in this session if you don't know anything about will or you know a little bit about will for your academic purpose. The concept of will I'm going to talk about applies in our country, Malaysia. So fellow Malaysia, we are pleased to have you to join us today. For now Malaysia, we hope that this session will help you for your academic purpose. Let us know your thoughts. Before I dig in further about wills, let me explain to you what is a will. Some might think a will is something you do only when you are old or when you reach a certain maturity age. Actually, it is not. You can write a will anytime, but bear in mind that having a will is about planning your assets or property. This allows you to not having the worries about your properties or assets fall into the wrong hands. A will is basically a document with legal effects where you may distribute your assets or properties to whoever you want. Basically, it's who you wish to give, whether to your family, your close relative, friends, charities, and etc. you name it. So today, if you are going to write a will, you will be called as testator. The person that will going to manage or distribute your property according to your will be called as executor for male or executrix for female. They will be the one that manage your property, such as apply something called grant of probate from court. The person that will get your assets or properties will be called as beneficiaries. So, to write a will as a testator, you must have those what we call as the element. So a person that write a will must firstly be of minimum age of 18. Secondly, you must be of sound mind. And thirdly, the will must be in writing and signed by you. Fourthly, two witnesses must be present at the time you are signing the will. But bear in mind that the witness cannot be the beneficiary or the spouse of the beneficiary in the will. Here comes the fun part. What is the property or asset that you may put it into your will? Okay, so there is actually two types of property. We call it as movable property or immovable property. So what constitutes movable or immovable property? I will give you some basic examples. A movable property, for example, means your bank account, your shares, your CDS account, vehicles, fixed deposits, unit trusts, and many more. This is classified as movable property. So the second type is immovable property, your houses, your land, your shops, your factories. These are all classified as immovable property. Just make sure that all your documentation is in order before you write a will. So the most common question you might consider is, what will happen if you didn't write a will? What will happen to your asset? So if today you didn't write a will and something happened to you, so your successor or your relative had to apply something called letter of administration or LA in short. This is in the case where your estate is valued for 2 million ringgit and above. If your estate is valued 2 million ringgit and below, then they need to go for small estates. Having your relative or family members to apply the letter of administration or small estate is much more complicated and more procedure is involved. It might be costly as well. And why we recommend to write a will is because if you today don't write a will, then the court will distribute your assets according to the Distribution Act in Malaysia. It may not be according to intention or wishes. As for letter of administration, where a deceased does not have a will, you will need to appoint two sureties to administer your assets, and it is very difficult to do so. Furthermore, it is time-consuming and costlier because of the administration law. That is why it is always much more convenient and straightforward if you write a will, as it is according to your wishes and less costly. So that is all today, guys, and we hope you enjoyed this session, and we shall see you in the next session. Do check out and subscribe to the channel below. Thank you.